Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones.
Well, there's a few reasons for that, sir. You know, one of the main reasons is I'd like some clarification on the record to be made without getting arrested due to the last appearance. As you know, was physically unable to get there. You're right about my motion. I didn't prove the just cause. I realized that I had to include some exhibits and proof that of what was going on, and I apologize for that. However, the last appearance, I was specially appearing to, by special appearance, I was attempting to make it by a special appearance to challenge the jurisdiction of the court due to several issues that have been unaddressed through the entirety of the case. The main ones being the discovery violations, the most recent changing of the discovery files to make all my motions look like I don't know what I'm talking about, and kind of confused a lot of the matters. And it's still the same thing. I mean, just a couple days ago, I got notice that there was another discovery update. I mean, we're well past the motions deadline, and there was a discovery update a week before that, and then another one like a week after, and then now more recent ones. And I just don't really feel like that's really granting me a fair chance at really defending myself when they want to change the names of the files and things like that, as I've already had submissions that had certain citations to their body cam footages and things like that have also been unaddressed. It doesn't really provide grounds for fair defense or a reasonable amount of time to be able to defend myself.
All right. Thanks, sir. All right. Here's, I guess, the record I'm going to make. We're set for trial to commence on Tuesday. Mr. Mann, I recognize how you are perceiving this, but I think the record is pretty clear. This case has been going on since 2022. By my count, there are at least 8 failures to appear, and that's at least 8 failures to appear in this case. You've after an Arguello advisement, you've agreed to represent yourself. You were advised and cautioned during the Arguello advisement that you would be required to, when representing yourself, to comply with the rules of criminal procedure, with any rules of evidence during the admission of any evidence. That has not actually even become ripe at this point because we've not had any hearings. This matter's been set for hearings to address your motions on a couple of occasions just since I've been the presiding judge over this case. And I believe in, let me just want to make sure on 11/26 that just myself have granted you extensions to file certain motions, giving you specific deadlines. And on 11/26/2025, I made it very clear what the final deadline was going to be for your motions to be filed, specifically 12/12 of 2025. Then we were scheduled for a motions hearing on 1/9 of 2026. That was the day that you appeared via WebEx. I found a failure to appear because you appeared via WebEx and did not give a adequate reason. You had indicated that you may be able to get here by 10:30, and I even stayed the warrant to give you that opportunity. Today, we're set for pre-trial conference 1 week away from the beginning of the trial date. You're still not here in person. These motions that you keep on talking about could have been addressed appropriately if you would have followed the court's orders during that time frame. And certainly, if there are issues of discovery that have happened that are not in compliance with Rule 16, the court will hear those. But those, again, you've been complaining about, or challenging, I should say, discovery issues, but you never present yourself on a date that we're actually scheduled to address those things. And you have to be here in person. You also have to be here in person for the trial. So again, we're set for a pretrial conference here. I have a jury questionnaire that I'm going to submit to the jury commissioner in preparation for Tuesday's trial. I'm going to bring in 55 jurors for that trial, and the court will be prepared. Well, let me ask the prosecution: is the prosecution ready to go to trial on Friday? I'm sorry, on Tuesday.
People are ready, Your Honor.
All right. So, Mr. Mann, we're set for trial. I mean, this, again, I'll address any pretrial issues or any discovery issues that have arisen in the last 35 days to determine whether there was any discovery violations. One thing you need to understand is the prosecution has a duty to continue to provide discovery. Oftentimes when they provide discovery just based upon, and I don't know how you're receiving your discovery, but again, these are just things I'll consider. And I'm just saying this for your information. Sometimes when they provide discovery, if they're doing it over what they call evidence.com, which is a system that they use to disclose information, sometimes that not the new discovery is provided, but then all the previously provided discovery kind of tags along with it, so it's included with it. I will address any discovery issues that may have arisen in the last 35 days if there's any new discovery that may exist. But those are things that I have to address when you're here in person. You're not here in person. I think I know you're aware that you have a warrant based upon the orders, the motions you filed and the last order I issued in this case. But we are set for trial on Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones and again, Ms. Jones is here only as advisory counsel, unless there's something in particular, Ms. Jones, you think I should be covering, or unless Mr. Duncan wants anything in particular covered. The one thing I will state is just based upon the nature of how things have been progressing in this case, I'm not going to require any witness testimony on Tuesday, so that at least there's a one-day window there for the people to just place any witnesses on call for what's going to happen the rest of the week.
Sorry, Judge, I don't mean to interrupt.
Yeah, no, I'm actually done with that.
Okay, I should have interrupted sooner. If Mr. Mann is not here today, are you finding that it's a failure to appear?
It is a failure to appear. I'm just giving him the information so we can proceed on Monday. He's got a warrant already. So yes, it is a failure to appear. But I still want to pass the information along so we can proceed on Tuesday. I said Monday. On Tuesday's the trial date.
So, excuse me. You said quite a bit there. I didn't really get a chance to respond to anything.
There's nothing to respond, sir. I'm just giving you.
Well, I got some things I need to address with the court before we can proceed, sir.
Well, sir, then you need to come to court. We will address those things when you're here in person.
Well,
I'm not going to.
I'm trying to tell you guys need to prove jurisdiction because there was a period of time I sat in prison for almost 9 months and there was no action on the case. That's a failure to prosecute. And I understand the statutory provisions on speedy trial, but there's constitutional provisions. And if the trial ain't had from the date of the start of the case between 180 days and there ain't good cause shown, that means you guys laid jurisdiction.
I will address, sir. I'm
covered
everything I need to cover.
I'm asking you to address it now because before we can proceed, I need you guys to prove that you guys have authority to try the case.
Sir, I've already addressed way more than I needed to. You're not actually here. It is a
failure. No, I am here.
I am protecting your right to a fair trial.
You gave my rights to all my motions. Without me even knowing it. I didn't give proper notice of that waiver of rights. You can't just be taking people's rights. The Constitution forbids that, and Constitution trumps everything. It doesn't matter what kind of order or ruling of law. If it's against the Constitution, you know that you can't be ruling like that. So can you address that, please?
All right, sir. What I'm addressing is that you're not here And the one thing I will say is you were on notice as to what the motion's date was, and you failed to appear on the motion's date.
Well,
You have to be in
actually, I
person.
attempted to appear by
in court.
video because I couldn't get there. And I know the record would reflect that. Because I did.
Sir, the record is made on this case. Okay. This matter is now in recess.
Okay.
You have a trial on Tuesday. You need to be here in person for your trial.
Yeah, I got you. You don't want anything or nothing, I got you. That's pretty much unfair as it gets.
This case centers on a familiar sovereign citizen argument that the court must first prove its jurisdiction before the criminal case can move forward. The legal question, however, was whether that claim provided a recognized basis under established procedural rules to delay the proceedings. Rather than focusing on the terminology itself, the court evaluated whether the argument met the legal standards required for judicial review. The individual viewed jurisdiction as the threshold issue, while the court focused on procedural compliance and the orderly administration of the case. This reflects an important principle of the legal process. Courts evaluate legal claims within an established procedural framework, not simply because a particular theory or phrase has been asserted. More broadly, this hearing demonstrates that legal terminology alone is not enough to obtain relief.